very good. Mr. Stubbs, are you ready to proceed?
Oh, yes.
All right, at your pleasure.
Mr. Olsen?
Do we have, Mr. Olsen, are you on the line, sir?
I am, Your Honor.
All right, still under oath, and are you ready to go?
Yes, sir.
Ready to go.
Very good, let's proceed.
Mr. Olsen, I'm going to continue where I left off in just a moment. I'm going to backtrack just a little bit. What was the reason for you to dismiss the charges on June 22nd, 2016?
I don't remember. I think.
Okay. Well,
I think that you had filed a motion to dismiss, and I filed a motion to dismiss without prejudice, and that was the order.
okay. Do you remember me providing you with a surveillance video footage?
I'm sorry, I do not remember that.
It was provided to you with my motion to dismiss, and it went to the court the same way. Does that recall your recollection?
No, I'm sorry, it doesn't.
Okay. Have you seen the video from the surveillance?
I don't recall what, I saw a number of videos, but I don't recall if there was one that you may have identified as the surveillance video.
It was from the DE trading post, a business close by. Does that recall your recollection?
I recall that there was a video that came from one of those stores that had picked up this incident.
Yes. So do you remember me providing that to you?
You may well have provided it to me, but I don't remember that it was you or someone from the city or.
Do you remember us discussing it at length?
No, I don't remember that. I'm sorry.
Do you remember me trying to explain to you how to maneuver the app once I gave you the footage?
No.
Okay. Do you remember anything in that video?
I'm sorry, I don't.
Okay. My next question, well, I'm just going to ask it, and if you don't remember, you don't remember. Was our discussions and the showing of that video part of the reason why you dismissed the charges on June 22nd, 2016?
I honestly don't recall.
Okay. Mr. Morris, could you give him my Exhibit 8, please?
Okay.
Okay, what does it say at the top?
Boulder City Police Department.
Okay, and then under that?
Declaration of probable cause and detention. And then there's some brackets.
Okay.
And misdemeanor complaint.
Okay, so is this in fact Mr. John Glenn's declaration of probable cause that he submitted to your office?
I don't know if this, let me look further here.
Look at the first line of the actual writing.
Okay.
Does that recall your recollection?
Yes.
So
the undersigned peace officer, Glenn.
Okay. Now, I'm interested in the handwriting. Do you see handwriting in the margins?
I do.
Whose handwriting is that?
That is my handwriting, I think. Looks like my printing.
Okay. And then on both pages, page 1 of 3 and 2 of 3, is there handwriting on both pages?
Yes.
Okay. So, and both pages, the handwriting is yours, correct?
Yes, looks like my handwriting.
Okay. When did you write that?
I have no idea. Subsequent to receiving this, when I reviewed it, I looked at the writing and made notes in the margin.
So it would have been when you first received it, correct?
I guess so, yes.
Okay, well, trying to get to better than I guess so. So what, Mr. Morris, can you give him Exhibit 10, please?
Yeah, I'm looking at Exhibit 10.
Could you look at page 93 of Exhibit 10, please?
Page 93. Okay, I'm on page 93.
Okay, so do you remember being in trial and being questioned about this exact issue?
No, I don't.
Okay, I'm going to read to you lines 1 through 9, and the question is me, and the answer is you, okay? So question, if you look at Exhibit 1, John Glenn's Declaration of Probable Cause, it's tab A, 5 pages in, do you recognize this? Answer, yes. Question, what is it? A, this is the copy of the Declaration of Probable Cause by Sergeant John Glenn. Question, on page 2, do you see the handwriting notes? Whose writing is that? Answer, mine. Is that the testimony that happened during trial?
I'd have to defer to you on that. I think that may have happened.
I'm sorry, I didn't hear you.
I would have to defer to you on that. I'm not sure. I think it may have happened.
Okay, but this is from the transcript that was authenticated earlier. Do you have any reason to believe this is not correct?
I have all kinds of reasons.
Yeah, and I just want to object. This is hearsay.
No, this is this. Well, I'm sorry, I didn't hear you, Mr. Stubbs. You were responding to the objection?
Well, yeah. First of all, this top part is foundational for the real question, going back to him saying that he did not remember. And so,
yeah, if he says he doesn't, you guys, if he says he doesn't remember, then you can introduce the prior statement as a prior inconsistent statement. There's case law that says a statement that I don't remember, where you did purportedly remember before, is inconsistent. So you are allowed to go ahead and ask the questions about that.
Thank you. So, Mr. Hunt, Mr. Olsen, do you have any reason to believe that this transcript is incorrect?
No.
Okay. Going down to line 23. Actually, line 21. 20. Question, we are talking about prior statements. Answer, these were just written notes I made after reading the complaint. Question, after the civil complaint? Answer, no. This was done before we did the dismissal without prejudice. Do you have any reason to believe that is not correct?
No.
Okay. Does that recall your recollection of when you wrote these notes in the margins?
Apparently, after the civil complaint.
Okay, let's read that again, okay? I'm trying to help you out here. I asked if it was after the civil complaint, and then you answered no. This was done before we did the dismissal without prejudice. Does that recall your recollection?
No.
Isn't it true that you testified at trial that you wrote these notes in the margins before you dismissed the 2016 complaint?
No, that's not true.
When did you write those notes?
Like I told you before, I don't recall when I wrote those notes. When I reviewed the complaint, I would occasionally make notes in the margins. When I say reviewed the complaint, I'm talking about the declaration of probable cause, which you pointed out in the other exhibit, and the report that the officer made of the incident leading up to the arrest or whatever other enforcement activity might be involved. And with the officer's report, I would make notes in the margins.
Okay. And is it customary for you to do that when you first receive these reports from the officers?
No, not always.
Okay. Did you, in this case, write these notes in the margins when you first received this from the officers?
Asked and answered.
Yeah, sustained. I think we established his understanding of that.
Okay. Was it before you filed the second complaint?
Asked and answered.
No, I didn't ask that question.
Well,
I asked if it was before the first complaint.
So he said he doesn't really recall exactly when he did it, but I guess we're trying to find out, we're trying to pin it down in between a certain period of time. So I'll go ahead and allow that. Okay. Sometimes when you make reference to another event, it jogs your memory of, when something happened. So go ahead, Mr. Stubbs.
Was this before you filed the second complaint in 2017?
This is speculation on my part, but I ordinarily would write those notes in the margin when I would first review the officer's report.
Okay, so that would have been in June 2016, correct?
You got, Mr. Stubbs, you got to, I know this is hard with audio video, but you got to make sure you let him finish his answer, okay?
Oh, I'm sorry. I thought he was. Were you finished, Mr. Olsen?
I guess.
Okay. So was that then, when you first reviewed the report, in June of 2016?
That would have been then, yes.
Okay. So then it would in fact be consistent with your trial testimony as set out in this transcript, correct?
Yes, I think so.
Okay. After you dismissed the case, did you review the case again?
Yes.
If you could go to page 94, lines 3 and 4. Question. After you dismissed the case, did you review the case again? Answer. No. Did you testify at trial that you did not review the case after you dismissed the charges?
Well, apparently from this particular transcript that you're drawing upon, the answer that you have written down here, or that I have written, was no. I don't.
Okay. So then you testified under oath at trial that you did not review the case after you dismissed it in June 2016, correct?
That is not what happened. I reviewed it. I don't know why that this says no, but I reviewed that case before filing the second complaint.
Okay, so between the dismissal and when you decided to file the second complaint, did you review the case?
Asked and answered.
No, that's a different question.
Overruled.
Yeah, I'm pretty confident that I did review it again.
Okay. When did you review it?
I can't say. I don't recall.
Okay. All right. Let's go to what's written in these margins. On that
Okay.
first page, do you see the part where it seems to say to avoid hitting, and then there's a little line?
Hold on a second. Which exhibit are we on now again?
Exhibit 8.
Okay. All right.
In the margin of the first page,
Yes.
there's a little line and it says to avoid hitting. Do you see that?
Yes, just before hitting, and I said to avoid hitting.
Okay. And so that was a correction of the officer's report just before hitting, correct?
I don't recall if that's why that's there, but one
Well,
could make
I'm going
that.
off of what you just said. You said just before hitting to avoid hitting. That's what you just
Right.
testified to. So I'm asking, are you correcting the officer's report?
I wouldn't do that without discussing it with the officer.
Well, are you making a note of something to discuss with the officer?
These notes are just to myself, and yes, sometimes they might cause me to contact the officer and have further discussion, but
Okay,
not
well,
all.
let's read the sentence. 7 lines down, where it starts the vehicle in number 2 lane. I'm going to read that, okay? And you tell me if I'm reading correctly. And this is from John Glenn's declaration. The vehicle in the number 2 lane.
We're having
is able
trouble
to-
following. Okay. I think me and my clerk are having trouble following you. Since you're going a little bit fast. What are you reading from? Which exhibit?
We're in Exhibit 8.
That's
and
the
then
police.
there's 7 lines down.
Exhibit 8 is the police report, right?
Yes, it's the Declaration of Probable Cause by John Glenn.
And what page?
The first page.
First page, about 7 lines down. Okay, you got that, Louisa?
Yeah, and it starts the vehicle
Okay.
in the number 2 lane. You see that?
All right, we're with you now.
Okay, it says the vehicle in the number 2 lane was able to stop. However, the vehicle in the number 1 lane had to slam on its brakes and skid to a stop just before hitting the subject. Did I read that correctly, Mr. Olsen?
You read this page correctly so far. No problem
Okay,
there.
so in that page, does it not say that the car hit Mr. Hunt?
Does it say that the car hit Mr. Hunt?
Yes, to where he skid to a stop just before hitting Mr. Hunt.
That's what the officer's report says.
Okay, but you already testified that he did not, in fact, hit him, correct?
Yes, based on the information that I had received, that is correct.
Okay, where did you get that information?
From discussion with the officer.
Okay, but the officer said he got hit. That's what's in his report.
Objection, misstates facts and evidence.
It does.
I'm sorry, he just testified that that's what the report said. I didn't misstate anything.
Let's just get through this. I want to know what the facts are. So, nothing's in evidence until I hear the answer. So let's keep going. Overruled. Just overruled. Let's go.
I'm going to make a record about you in a minute. You just sit down and be quiet.
The court finds in the best interest of the minor child and makes the following findings.
For the record, I don't say these things to hear myself talk.
An absolute decree of divorce is granted.
By September 6th, you will pay $6,000 of what is due. Best interest is not, can you give her a pony?
And ask the question, make sure we're being accurate with what the actual states.
Whoa, let's just get through this. I want to know what the facts are.
So, Mr. Olsen, but the officer stated in his report that he got hit, correct?
It would look that way.
Isn't it true that you got the information he didn't get hit from the video of the incident that I supplied to you?
I don't remember. I'm sorry.
Okay. Okay.
In fact, I don't think I could even tell you what this MD to PH, PH to MD, maybe this...
Do you remember telling me prior that that meant McDonald's to Pizza Hut, Pizza Hut to McDonald's, McDonald's to Pizza Hut, referring to...
Hold on. Mr. Stubbs, but yes, you're going really way too fast for us to hear through the audio video. I mean, it's difficult enough without you being in person, without people being in person. So
all right,
you got to slow down a little bit for us. Go ahead.
Okay. So do you remember explaining to me when we were discussing the video in June 2016 that the 1, 2, and 3 are the 3 times that Mr. Hunt crossed the street, and the number 1, the MD is McDonald's and the PH is Pizza Hut? Where there's a McDonald's on one side, a Pizza Hut on the other. And so the first time it was McDonald's to Pizza Hut, second time it was Pizza Hut to McDonald's, and third time it was McDonald's to Pizza Hut. Do you remember that?
That makes sense.
Does that recall your recollection?
Now I can, yes.
Okay. So you remember that conversation with us, correct?
No, I don't remember having the conversation with you, but I remember that MD to PH means McDonald's to Pizza Hut. And then PH to MD means Pizza Hut to McDonald's, and then MD to PH means McDonald's to Pizza Hut. I don't recall that you and I discussed that, but that seems to look correct.
Okay. So then to avoid hitting, is that not correcting the erroneous report?
That's a note that I made in the margins. I didn't correct the report. I don't think, did I?
Well,
until later.
I understand you didn't change the report. I meant, is that a note pointing out the erroneous report?
That's a note in the margin.
Okay.
It says.
Was that part of? Oh, sorry. Please go ahead.
It says to avoid hitting.
Okay. Was that part of the reason why you dismissed the case? Because the officer's report was incorrect?
No.
Okay. Going to the second page. Now,
okay.
I see the margins to where it says NHP video, BCPD audio.
Right.
Okay. So at the time you wrote this, you knew about the NHP video, correct?
Apparently I knew about an NHP video. Yes, it looks like that from the notes
And you
that I made.
testified earlier that you wrote these the first time you looked at the report, which would have been in June 2016, correct?
What was that again? I'm sorry.
And you testified earlier that you wrote these notes when you first saw this report, which would have been June 2016, correct?
I don't know. It could have been when I first got the report. It could have been when I picked it up several times between then and when it got filed the second time. You know, I didn't just do that final complaint all at once. It was stretched out over a year's period of time.
Okay. All right. Going to the next margin. It says, the reason he decided to exercise his constitutional rights. Did you write that?
That is my writing.
Okay, and then there's an arrow pointing to Officer Driscoll. Officer Driscoll, do you see that?
I see an arrow coming up off of that. The reason he decided to exercise his constitutional rights, pointing in the direction of Officer Driscoll in the report.
Okay. And that sentence, I'll read that. It's 4 lines from the bottom, says, the subject was placed in my patrol car, and that is when Officer Driscoll advised me that she had just stopped this subject for failing to stop for our decoy in the marked crosswalk and cited him. Correct? That's where the arrow points?
That appears to be where the arrow is pointing, yes.
So then is the reason you wrote that note because you thought that he was exercising his constitutional rights as a result of getting caught up earlier in this crosswalk thing?
I don't recall thinking about it that way, no.
Okay. But you did recognize that he was exercising his constitutional rights, correct?
I did not. That's why that's in quotes. Well, I didn't put it to close quotes, but open quotes. Exercise his constitutional rights was something that was being claimed.
Okay. Who claimed that?
You did, or your client did.
Okay. And that discussion, wasn't that in June 2016 before you dismissed it?
I don't recall when that discussion was.
Okay. Did we have any reason to discuss this case after it was dismissed and before Mr. Hunt filed his civil rights complaint?
I don't think so.
So wouldn't it have had to be before you dismissed the charges?
I can't say. I don't recall.
Okay.
I don't recall when I wrote that.
I think he was asking when the conversation was. You've already been pretty clear about, you didn't know when you wrote the notes, but I think Mr. Stubbs is asking when the conversation was with him when you probably obtained this information of his position. Is that correct, Mr. Stubbs?
Yes.
Is that what you were asking?
Yes, that makes it simpler.
All right. And I think his answer was the same. He doesn't recall when he discussed that with you. Is that
okay?
Go ahead.
All right. So, Mr. Olsen, was one of the reasons that you dismissed this claim because you were in some way protecting and upholding Mr. Hunt's constitutional rights?
No.
Okay. But you at least considered it, correct?
No.
You didn't consider whether you were exercising or whether Mr. Hunt was exercising his constitutional rights?
I didn't. No. The note that I made regarding exercising his constitutional rights did not reflect my opinion of that particular issue. I was merely putting that in there as part of my notes.
Okay. Were you considering not concluding, but considering whether Mr. Hunt was exercising his constitutional rights?
No.
Okay. Isn't it true that on Mr. Sergeant Glenn's video, on his dash cam video, he admits that he knew that Mr. Hunt was making a, quote, political statement?
I can't speak for Officer Glenn or Sergeant Glenn.
Okay. I was asking whether you heard it on the video.
I don't recall hearing it on the video or elsewhere.
Okay, on page 94 of Exhibit 10. Line 16, question.
Just a minute, I'm not...
Excuse me.
I'm sorry, was that you starting to speak up, Mr. Morris?
No, that was the witness. Give him some time to get to the page is what he was asking for.
Oh, yes, absolutely. Let's go ahead. I need time too. We're going back to Exhibit 10, right?
Exhibit 10, page 94.
And page 90 what?
4.
94. Mr. Olsen, tell us when you are there, sir.
I have that now, Your Honor.
All right, thank you. You may proceed, Mr. Stubbs.
On 16, question. You had notes indicating he was trying to exercise his rights. Answer. That's right. Did you testify at trial that these notes meant that he was trying to exercise his rights?
Well, if you look at the notes, they speak for themselves.
That's not the question. Did you testify at trial that those notes indicated that he was in fact trying to exercise his rights?
Asked and answered.
He didn't answer my question.
Well, no, it's not the same question. I could articulate why, but I don't need to interject my opinions into this. But so go ahead, Mr. Stubbs.
Isn't it true, Mr. Olsen, that you testified at trial that the notes were indicating that Mr. Hunt was trying to exercise his rights?
No.
Then why did you answer that's right to that question?
Objection, it hasn't been, he stated that he didn't say that. And to introduce this would be hearsay because it would be Miss, what's her name, Dick Hutt, who would have to testify as to what Mr. Olsen, she believes, said or didn't say. This is her testimony, if you will.
Your Honor, that did happen. Miss Dick Hutt did testify that she took the notes and that this in fact was correctly of what she heard him say. She authenticated this document.
Yes, so the document is authenticated and it's not hearsay under 51035 for the reason that this is a transcript, we know that, of testimony, we know that. It's not disputed that Mr. Olsen gave his testimony under oath, and it was at a prior trial or hearing. And further, Mr. Olsen is now on the stand available on cross-examination to confront the statement. So all of the elements have been met to deem this not hearsay under the hearsay rule. The only remaining issue then is this sufficiently reliable such that when I balance the probative value against the prejudicial impact, that it should come in. I'm going to allow this page 94 to be used for questioning, and it is admitted but I'm letting it come in for whatever weight I'm going to give it at the end of all of the testimony. But it is in fact admissible, these statements that are in here. All right?
Thank you.
Now, I may give it a lot of weight, I may give it no weight, but I need to hear all the testimony first, all right?
So, Mr. Olsen, why did you answer at trial, "That's right," to the question, you had notes indicating he was trying to exercise his rights?
I didn't.
Are you saying this transcript isn't correct?
Yes.
Are you sure your memory isn't correct right now?
Argumentative.
Yeah, it's sustained. Look, this isn't complicated, guys. Mr. Olsen said he had that note on the on that police report, and he said that he might have, and that's the note referencing the what he said is probably the defendant's position that he was exercising his constitutional right. And Mr. Olsen said that he probably obtained that his knowledge of that position from conversation with you, Mr. Stubbs, but he doesn't know when that conversation was. So at this trial, though, he's saying that, this is my understanding of what he's saying here. At trial, the question was, you had notes indicating he was trying to exercise his rights. Well, to me, that is consistent with what he just said earlier here, which is, he had a note indicating that it was your position that the defendant was exercising his rights, and so he said that's right. I see these as the same thing. It's just a little bit different semantics. So Mr. Stubbs, I think you got to move on because it's argumentative the way you're phrasing the questions now.
Okay, so going back to before the break, we talked about July, and you testified that you did not file a new complaint in July, and that Ms. Thackeray was still working for your office in July 2016, correct?
I think that's correct.
Okay. So in August 2016, did you file the new complaint then?
I don't believe so.
Was Ms. Thackeray working at your office in August 2016?
I don't know.
Your Honor, if I may interject, we'll stipulate that Ms. Thackeray's last day was April 6, 2017, and a new complaint wasn't filed until after that date.
Perfect.
So April 6, 2000, you said April 6, 2017 was her last day, and the new complaint, the second complaint, was filed after that. Yes.
That's correct.
Okay. Mr. Stubbs, would you accept that stipulation, sir?
I do. Thank you.
Okay.
All right. So then Ms. Thackeray not being in the office could not have been an excuse for you not to file in August 2016, correct?
Correct.
Okay. Why didn't you file it by August 2016? And by it, I mean the second complaint.
I was in the process of becoming retired, and I had a lot of things going on at that time. I had worked on that complaint on and off since we first received an order from the court dismissing it without prejudice. I worked on it on several occasions, did legal research on the subject, and it would routinely get shoved to the bottom of a pile of work that I was doing. And like I say, I was trying to wrap things up in my office, and had it not been for the fact that we were served with the civil complaint, it might have gotten away from me, but the civil complaint reminded me that I needed to get that finished up and get it filed, and so that's what I did.
Okay, so when did you decide to retire?
Well, I didn't really decide that myself. I was kind of invited to retire, but
Okay,
I
so
retired.
before you were invited to retire, were you thinking of retiring?
No.
Perfect. When were you invited to retire?
I thankfully can't remember the exact date and time that occurred either.
Would it be February of 2017?
I don't know. That date name that month doesn't ring a bell with me.
So, Mr. Stubbs, let me ask a question here. Mr. Olsen,
Yes, sir.
so I guess since I'm the one who has to make the decision here, I need to make sure that the facts are clear in my mind. That's why I have this limited question here. So I understand your position is that that the filing of the civil complaint kind of triggered back in your mind that you had been working on this second complaint, and that having been brought in back into your mind, you went ahead and got it filed. Is that basically correct?
Yes.
So if that civil complaint had not been filed, if it had never been filed, was there anything going on at that time with that second complaint that would have led to it eventually being filed, or would it have just languished and disappeared after you retired? Do you know?
Well, if I'd gone, then yes, that would have been exactly right. But I was still there, and there was still time within the statute to file the complaint. I figured, okay, I'll just finish this up. It's one of my final official acts as the city attorney, and that was it.
I appreciate that. Was there, again, if that civil complaint had not been filed, was there any policy or procedure in place that would have brought back within your radar the work that was being done on the second complaint?
At that time, no, it was the civil complaint that reminded me again.
All right, I think I understand your position. Thank you. Mr. Stubbs, you may follow up with that if you think it's necessary.
Thank you very much. If Mr. Morris, if you could give him your Exhibit 7, your marked Exhibit 7, Affidavit of David Olsen.
Their Exhibit 7.
Yes.
City. Let's have a moment for us to find it. So this is now the city's Exhibit 7, right? Okay.
Yes.
Okay, not a problem. Go ahead.
All right, Mr. Olsen, if you look at paragraph 9.
Yes.
I'm going to read that, and you tell me if it's read correctly. In or about February of 2017, I determined I would retire on June 29th, 2017. Did I read that correctly?
Yes, I probably wouldn't have used the same voice inflection, but yes, February 2017, I determined that I would retire on June 29th, 2017.
And in fact, you were pushed into retirement, you said before, correct?
Yeah, nudged in that direction.
And in fact, you testified earlier that you did not contemplate retiring before you were nudged into retirement, correct?
I'm sorry, would you say that again?
You just testified a few minutes ago that you did not even contemplate retiring until you were nudged in that direction, correct?
No, I did not even contemplate. I'd done a number of things in anticipation of being invited to retire.
Okay, in August 2016, you were not, in fact, preparing for retirement in August 2016, correct?
I was not what in?
Preparing for retirement.
Well, I don't recall that it was at precisely at that time, no.
Okay, because you had previously testified you were, so that testimony was not true, correct?
I don't recall what testimony you're referring to that was not true. I'm trying to testify truthfully to the best of my recollection.
I asked the question why it was that you had not filed the second complaint in August 2016, and one of your reasons was because I was preparing for retirement. Do you remember giving that?
That's what I have. That's what I have
Okay.
in my notes here. That from just a short while ago. That the reason that the complaint hadn't been filed by August 2016 was not because of that Ms. What her name was, not because she was not in the office anymore, but it was related to Mr. Olsen being in the process of retiring. That's what I have in my notes.
Line 11 in that affidavit says, filing of the new complaint was delayed because I was swamped without a paralegal and preparing for retirement.
Oh, I'm going to get to that. I'm going to get to that. Right now, I need your testimony about August 2016. So you testified as to two opposite things. I need to know which one is correct. On one hand, you testified earlier that you did not file the complaint in August 2016 because you were preparing for retirement. But on the other hand, you testified that you were not contemplating retirement until February 2017, and that you were not contemplating retirement in August 2016. So which one of those is correct?
I'll tell you, my head is spinning. I can't keep up with.
Okay. There's two opposite statements, and that cannot both be true. So I'm asking which one is correct. The first statement, testimony you made under oath, is that the reason why you did not file the complaint in August 2016 was because you were contemplating retirement. Then you testified that, that's number one. Number two is you testified that you did not contemplate retirement until February 17 when you were nudged in that direction. And therefore, you did not, that was not a reason for you not to file the complaint in August 2016. Of those two things, which one is true?
I'll stand on the affidavit. That's the affidavit is accurate, to the best of my knowledge.
I have to jump in here again to make sure I understand. So looking at your paragraph 9, it says in or about February 2017, you determined you would retire June 2017. Before February 2017, were you contemplating retirement or any reason to believe that might be a possibility? That was before February 2017.
Well, I knew that this possibility was coming up.
Well, all right. Can you help us put a time frame on that? Like when? Was it back in August of 2016 when you started thinking that was a possibility, or was it closer to February 2017, or do you not recall?
I really don't recall, Your Honor. I'm sorry.
That's all right. I'm just trying to piece together the facts, and I won't form any opinions on what it all means till after I hear everything. So go ahead, Mr. Stubbs.
Okay. The second part of that line 11 or paragraph 11 of the affidavit was that the filing of the new complaint was delayed because you were without a paralegal. That was not true in August 2016, was it?
I don't. Did we determine when Tara finally left?
Yes, it was stipulated August 6, 2017.
That's incorrect. It was stipulated April 6, 2017.
You're correct.
Yeah.
I misspoke.
Thank you for
April
correcting.
6, 2017.
Okay, on April 6th of 2017, I was in the process of wrapping things up with my, my 17 years with the Boulder City Attorney's Office.
Yes, and you signed an affidavit under penalty of perjury that the reason there was a delay is because you were without a paralegal, and that could not have happened prior to April 6th, 2017. Correct?
I believe the affidavit says I was swamped without a paralegal and preparing for retirement.
And Mr. Olsen, I'm trying to point out that this affidavit cannot be true. So again, I ask you, if Ms. Thackeray was not gone till April 6, 2017, how in the world could that have been a delay for you to file the new complaint prior to April 6, 2017?
Are you following that okay, Mr. Olsen?
Yes, I am.
Okay, no, take your time to respond. I want to make sure that we all understand what happened here.
Okay.
Because paragraph 10, it looks like you're saying your paralegal resigned after you announced retirement, and that would have been, so after June 29, 2017. But Mr. Morris, Mr. Morris and Mr. Stubbs stipulated that the paralegal actually retired, or her last day was April 6, 2017. So that suggests to me that the paralegal was gone before you retired, unless she wasn't gone by April 6, 2017. So to me, it seems like there's a discrepancy there.
Well, Tara was gone for several months before I retired. So my paralegal was gone.
Go ahead.
My paralegal was gone and had accepted employment with an insurance company somewhere here in Southern Nevada. I recall that. And so the filing of the complaint, I had been working on it, but it was delayed because I was swamped. I didn't have a paralegal at the time, and I was preparing for retirement.
So is paragraph 10 inaccurate then?
After I announced my retirement, my paralegal resigned and accepted employment elsewhere. No, I think that's consistent with what I said. When I determined that I would retire on June 29th, after I announced that, she resigned and went to work with somebody else. It makes sense that she would do that, considering the fact that the attorney she worked with was now leaving.
But I thought that she resigned before June 29th. I thought she resigned on April 6th.
Yes, that would be correct.
So she resigned before your retirement, but then paragraph 10 says she resigned after your retirement. I'm just having trouble reconciling that. But go ahead. Your attorney can.
If I may, on paragraph 10, it says after I announced my retirement.
Right.
So it's perfectly feasible that he announced in February 2017, then she resigned, and then her last day was April 6th, 2017. That's perfectly consistent.
See your interpretation. Do you think that's what happened, Mr. Olsen?
Yes, that's accurate. Or it seems accurate as I'm sitting here today.
All right. Thank you for clarifying. So the announcement of your retirement is not the same as the date you retired. All right. Thank you for explaining that. I'm sorry I had to interrupt, but I wanted to make sure I understood. Go ahead. I have no more questions.
So my whole point with this, Mr. Olsen, is that if not having a paralegal was your excuse for the delay, and you had your paralegal up until 2017. That means that there was no excuse for the delay until April 6th, 2017. Would you agree with that?
No.
How can you use Ms. Thackeray as an excuse for the delay if she wasn't gone until April 7th?
Sorry, that faded out.
Yeah, that faded there. If
Okay.
you could restate that question.
I will restate. How can you use Ms. Thackeray not being there as your paralegal as an excuse prior to April 7th, 2017, if she did not leave until April 7th, 2017?
How could I try to use her as an excuse for that?
Yes.
I don't recall that was part of my thought process at the time. I knew I had a lot of work that was not completed. I didn't have a paralegal. I was trying to get my office wrapped up and ready for retirement, and so the new complaint sat on my desk for some period of time.
Okay, so does that mean that you prepared the new complaint after Tara left?
I prepared part of it. Please understand that during that year's period of time, I worked on it several different times. I'd done research, had done drafting, and so this was just kind of finish things off and file the complaint.
Okay, but you would agree that it's improper and incorrect to use you being without a paralegal as an excuse before your paralegal actually left, correct?
No. But I didn't use,
use her not being there as an excuse.
Now that you mention it, I didn't use her for any purpose on this particular legal matter. She had other things. She had other things that she was doing at the time.
So when you try to make the excuse in the argument that her being gone is a reasonable delay, that excuse and argument is not correct. Correct?
No.
Please explain this to me, Mr. Olsen.
Explain. The affidavit explains it.
Yes. And in the affidavit, you claim the excuse to try to excuse the delay as you were without a paralegal. Please explain to me how you can do that before you were without a paralegal.
Before the filing of the new complaint, there was a period of time when things were delayed because I was literally swamped and I did not have a paralegal at that period of time and I was preparing for retirement. So the complaint sat on my desk for a period of time, and then when we were served on May 31st, that's when I realized that the time was running out on my filing of the complaint, and so I filed the complaint.
Okay, so that period of time was between April 7th, 2017 and May 31st, 2017, correct?
Right. I was without a paralegal at that time.
So the only time you can use those excuses is for the time period between April 7th, 2017 and May 31st, 2017, correct?
No. I had worked on that, like I say, I had worked on that complaint on and off for some period of time during that year's period. From April 7th until I was retired, I was without a paralegal. During that same period of time, I was also preparing for retirement, and I was feeling pretty swamped. But quite frankly...
But that wasn't true in August 2016, correct?
So, Mr. Stubbs, yeah, I think I got a really good picture of what happened between August 2016 through April 7th, 2017. That's one period in time when the paralegal was there. And then from April 7th, 2017 through May 31st, 2017, I've heard the testimony of Mr. Olsen that period of time the paralegal wasn't there and he was swamped trying to wrap up things, trying to leave. So I understand the positions of the parties and the timeline, and I don't know that any further questioning is going to bring out any facts that different than what we have. So why don't we save that for a closing argument?
Okay, there we go.
But I understand exactly your position and where you're going with this on both sides. Okay?
Okay, thank you. Okay. Mr. Hunt, let's go to that second complaint that you filed on June 5th, 2017.
Mr. Hunt or Mr. Olsen?
Or I'm sorry, yeah, Mr. Olsen. If Mr. Morris, could you please hand to Mr. Olsen proposed Exhibit 7, the June 5th, 2017 criminal complaint?
From the city's or Mr. Hunt's exhibit list?
From Mr. Hunt's.
Once again, exhibit number 7, you say?
Yes.
Okay.
Okay, if we could look at count 4, obstruction. Now, you prepared and filed this complaint, correct?
Yes.
Okay. So in count 4, I'm just going to read it. It says, if you could follow along and just confirm that what I say is true. That said defendant did willfully hinder, delay, and or obstruct a public officer in the performance of his or her official duties, to wit, defendant did prevent a lawful public safety law enforcement exercise, namely a joint crosswalk enforcement activity involving officers of the Boulder City Police Department, Mesquite Police Department, and Nevada Highway Patrol, by walking back and forth in a crosswalk being used for the enforcement activity, thereby obstructing traffic and obstructing, preventing, and interfering with the enforcement activities, all of which occurred at Juniper Way and Nevada Highway within the corporate limits of City of Boulder City. And then there's an and, but did I read that correctly?
Yes, you did. Those were the exact words.
So the to wit, what he's actually accused of doing is simply walking in the crosswalk during the enforcement activity, correct?
Objection. He's asking for a legal conclusion. That's before the court to make that determination, not Mr. Olsen.
Nope, I'm asking for what he actually charged Mr. Hunt being with. What crime and what facts that Mr. Hunt was being charged with in count 4.
Well, let's two different things. What crime he was charging him with, or what are the facts that supported his view that there was a crime? It's kind of a compound. Why don't you ask one or the other?
Okay, Your Honor, the Sixth Amendment requires that you state the specific facts in the complaint that are offensive, that violate the law. That's a requirement. That's what a to wit is. That's why the to wit is there. So I'm asking Mr. Hunt, I'm asking Mr. Olsen what Mr. Hunt was accused of doing.
All right, that's a fair question. If you're asking Mr. Olsen what his view was of what Mr. Hunt was accused of doing.
So, Mr. Olsen, what was Mr. Hunt accused of doing?
He was accused of obstructing traffic and obstructing, preventing, and interfering with the enforcement activity of the Boulder City Police Department, Mesquite Police Department, and Nevada Highway Patrol. By walking back and forth in a crosswalk being used for the enforcement activity, thereby obstructing traffic.
Okay, so his actions that you were accusing him of doing to obstruct is him walking back and forth in the crosswalk, correct?
Him walking back and forth in a crosswalk where a joint enforcement activity was occurring involving officers of the BCPD, Mesquite Police Department, and Nevada Highway Patrol.
Okay, now you charged him under NRS 190, correct?
197.190?
Yes.
Yes.
Okay. Are you aware that 197.190 requires due notice before a person can commit obstruction?
Yes, and that due notice can be provided by publication in the newspaper. It can be provided by a variety of other means.
Perfect. Was there a press release by the Boulder City Police Department?
I don't recall.
If you could look at Exhibit 2, Mr. Morris, if you could help him, please. Exhibit 2 of my proposed exhibits.
Okay.
Does that recall your recollection of whether or not there was a press release?
No, it doesn't. I don't remember ever seeing this. I don't remember ever being showed.
I'll represent to you that this was produced in discovery by the City of Boulder City.
Okay.
By Mr. Gary Booker to me as the press release. I'll just represent that to you. Okay.
Okay.
And going 4 lines down where it starts, Nevada state law requires.
Okay.
Are you there?
Yes.
Okay, I'm going to read that. You tell me if it's correct. Nevada state law requires pedestrians to use sidewalks, crosswalks, and pedestrian bridges. Did I read that correct?
That's what the words say, yes.
Okay, so the press release specifically told people to use the crosswalk, correct?
I'm not going to make that kind of an assessment. I don't know. You'd have to ask Mr. Booker. He's the one.
No, isn't that what the words say, though, in the press release?
The words say this enforcement will include high pedestrian traffic areas both in Boulder City and all around Nevada.
And then it says in the middle of line 4, Nevada state law requires pedestrians to use sidewalks, crosswalks, and pedestrian bridges, correct?
Yes.
So the press release, in fact, tells the entire public, use this crosswalk, correct?
I can't make that determination. I would say that it gives notice.
That they need to use the crosswalk, correct?
This is a press release giving notice to the public that there would be a joint enforcement activity in Boulder City.
And that they needed to use the crosswalk, correct?
I can't argue with that, Mr. Stubbs. I wasn't involved in this part of it.
Well, I'm just pointing out that the press release, and you seem to be arguing with what's on the written page. I'm pointing out that the press release tells people to use the crosswalks. Isn't that true that the press release itself tells people to use the crosswalks?
Nevada state law requires pedestrians to use sidewalks, crosswalks, and pedestrian bridges. not quite as simple as you're trying to make it, but yes, crosswalks are definitely included in that language.
Thank you. Wasn't in fact Mr. Olsen legally authorized to be in the crosswalk at that time?
Mr. Olsen was not
I'm
in
sorry,
the crosswalk at no time.
I'm sorry, I misspoke. Wasn't Mr. Hunt, in fact, legally authorized to be in the crosswalk at that time?
I believe Mr. Hunt said that he was there to do that activity to infinity, and I don't think he's authorized to do that.
Okay.
Not when they're engaged.
Mr. Morris, would you please get Mr. Olsen my Exhibit 12?
Okay, that's an Oasis Reporting Services document?
Yes. And
Okay.
I'm looking at page 29 of that document,
Okay.
which is page 8 there's 4 in a page. So it's on actual page 8, which includes page 29.
Page 8.
Yeah, well, it's page 29 of the deposition, page 8 of the exhibit.
Page 29. I'm sorry,
Who's the deposition, page 29, which is, since there's like 4 pages per page, it's actually of the transcript. It's page 8 of well, how do I explain this? There's the actual transcript of the deposition as printed has 4 pages
okay,
per page.
I'm looking at page 29 by Mr. Blake.
Okay.
Yes.
Okay.
That's it. So, isn't it true that you testified under deposition that Mr. Hunt was authorized to be in the crosswalk at that time?
I'd have to read down through this page. May I do that?
Why don't you go line 14 through 18 of page 29 and see if that recalls your recollection.
Okay. So you, to shorten things down, ask if Mr. Hunt was authorized to be in the crosswalk. And my answer was yes. And so the next question is, how did he violate the statute?
Wait. That's Mr. Olsen. That's my
Yes.
question. Was Mr. Hunt legally authorized to be inside that crosswalk?
Not in the way he was using the crosswalk, in a dangerous way.
So just a second. Let's go back to this. I'm going to read it, the question, line 14. So I guess here is my ultimate question. Just being very honest with you, your testimony is that John Hunt, he entered the strip, the crosswalk. He was authorized to be in the crosswalk, correct? Your answer, yes. Isn't that true?
That was my answer. Yes.
Thank you.
He was authorized to be in the
So he was in fact authorized to be in the crosswalk, correct?
Yes, but not in the way he was using the crosswalk.
Thank you very much. That required a yes or no. Was Mr. Hunt given any notice that he was not supposed to be in the crosswalk?
I have no idea.
Isn't it true that you testified in this transcript that you were not aware of any notice that was given to Mr. Hunt?
And I still am not aware of any notice that was given to Mr. Hunt.
And isn't it true that you also testified that you were aware of no evidence that any signs were put up to the public that they could not use the crosswalk?
I wasn't a party to that activity itself.
So,
Okay.
Mr. Stubbs?
Yeah.
Mr. Stubbs, you're spending a lot of time here, it seems, trying to litigate the issue whether there is a valid reason for the arrest, and I need you to focus on the state of mind of Mr. Olsen between the time of the first complaint and the second complaint. I mean, this might be all very helpful to understand whether the arrest was valid, but that's really not the issue in front of me. Right?
He was not arrested under this charge. This was an add-on charge in the second complaint.
Right. So then let's focus on rather than whether there was obstruction or not obstruction, but what was in Mr. Olsen's state of mind about the validity of an obstruction charge, and I need to know that between the first complaint and the second complaint.
Yes, and that's where I'm
Okay, go ahead.
Okay, so Mr. Olsen, if there is no evidence of any notice, and NRS 197-190 requires notice, why did you charge him with NRS 197-190?
Because I believed that there was sufficient evidence presented to me that would enable me to prove the case beyond a reasonable doubt.
Okay, does not proving the case beyond a reasonable doubt meaning that you have to meet all the elements of the statute?
Yes, it does.
And is not one of the elements of the statute that due notice was given?
I'm sorry, what was that?
Isn't it true that one of the required elements of the statute is that due notice is given?
Yes, we've discussed that at length.
Okay, so, and then you just admitted you had no evidence whatsoever that any due notice was given, correct?
No, that's not correct.
Okay, let's go to the transcript then. Exhibit 12, page 67, lines 16 through 22.
Page 67. Say that again so I can line up the numbers here.
It's that same exhibit 12, page 67, lines 16 through 22.
67.
It's on page 17 of the transcript and page 67 of the transcript, upper right-hand corner.
Yeah, we're looking. Okay, got it.
Okay, now this is the question. Again, we talked about this before, but was there any evidence that anyone put John Hunt on notice that he couldn't use the crosswalk before he crossed the street? Answer,
Well,
I don't know.
Well, it was my... Sorry.
But you're not aware of any notice. Answer, I am not aware of any. Question, are you aware that NRS 197-190 requires due notice before someone can be guilty of obstruction? Answer, I am aware of that. So, Mr. Olsen, what evidence did you have for this important element of obstruction that would then let you file this charge?
It's my understanding that the police officers put notice in the newspaper.
Okay, and we looked at that press release, correct?
Right.
And the press release told them to actually use the crosswalk, correct?
Not in a manner that is illegal. That was never allowed.
Okay, but in order for it to be illegal, it actually has to be against a statute, correct?
Yes.
Okay,
That's an element
so
of the
if Mr.
statute.
Hunt wants to protest, and he's told to use the crosswalk, and he's not given any notice not to use the crosswalk, isn't it then proper for him to be in the crosswalk protesting?
No.
Okay.
Not at all.
And wasn't he authorized, legally authorized to be in the crosswalk?
He, again, I have no doubt that he was legally authorized to use that crosswalk in a legal and safe manner. But that was not the case from the evidence that was presented to us.
Okay. All right. we're going to move on. Is it another important element of obstruction that no other provision of law apply?
Yes.
Okay, so you cannot have an obstruction if any other provision of law applies, correct?
I guess so.
Okay.
Not
Did
sure
another provision of law apply at that time?
several provisions of law applied at that time, but not
Awesome.
necessarily, not
So-
necessarily to, okay, go ahead.
Let him finish, please. Go ahead.
I did stop as soon as I
No,
realized
you-
he was still talking.
Yeah, finish your response.
Not necessarily to that particular language in the statute.
The language of the statute specifically says that in order for it to be a valid obstruction charge, no other provision of law can apply, correct?
And I'm saying no, there are other provisions of law that can apply.
Yes, so you're supposed to use other provisions of law and not obstruction if there's another provision of law that applies, correct?
Your Honor, I think we're getting into it off track here, into an area that really applies to Your Honor's decision.
Yeah, it's a legal question here, Mr. Stubbs. I mean, the whole point is, you know, it's something, it could be obstruction unless there's another statute that says you're allowed to engage in whatever activity you're engaging in. So, I mean, I understand the law here. You guys, go ahead.
Mr. Olsen,
Yes.
is the First Amendment a provision of law that applies in this case?
I think we would all agree that the First Amendment applies to just about everything as long as you're exercising it safely, which this guy was not doing.
Okay, so your objection is in the way he was exercising his First Amendment rights then, correct?
As I reviewed the evidence, my objection and concern was the danger that he was placing himself and driving public into.
Okay. But you would agree that he was exercising his First Amendment right, correct?
You cut out there. Can you state that again, Mr. Stubbs?
And Mr. Olsen, you would agree that he was exercising his First Amendment right then, correct?
No, I would not.
Would it surprise you if the city has taken the opposite position in their filings?
Objection. That's not accurate. That's just false.
Oh, let me.
Well, so let's see if Mr. Stubbs has any evidence to back up the predicate in his question.
Oh, absolutely. Okay. There was a filing done on 2018, opposition to appellate's motion to dismiss for vindictive prosecution on First Amendment grounds. It's already part of the court's record. It was filed by Mr. Steve Morris.
And you cut out a little bit. What was the date of that?
October 10th, 2018 at 4:18 p.m.
Yeah. And again, that's well after the original complaint had been filed, and Mr. Hunt filed his federal civil action alleging that he was protesting. But the facts are very clear that Mr. Hunt himself stated that he wasn't protesting at the time. He was going on a walk.
Mr. Hunt absolutely said he was protesting at the time. That's in every record everywhere. And in fact, Judge Mahan found that Mr. Hunt was protesting.
That is incorrect.
That's in the record as well.
I'm not too interested in what Judge Mahan found, but I think what would be relevant here is prior to the filing of the second complaint, what was Mr. Olsen's view on whether Mr. Hunt was exercising his First Amendment rights? That's the relevant inquiry.
And Your Honor, I'm saying that the city is stopped from now saying that Mr. Hunt was not exercising his rights because they already admitted to it in their filings in this case.
All right. Well, whether there is estoppel is a legal issue which if you want, you can argue or brief when we're done with the evidence.
Okay, and my question was, would it surprise Mr. Olsen to know that the city had acquiesced that Mr. Hunt was in fact protesting?
Well, and that's a legal argument, and it's not accurate, and I state my prior objection.
So we don't, hold on. So, Mr. Stubbs, I'm going to allow you to introduce into evidence the brief that you're referring to so I can make a determination on whether there's
Thank you.
whether there is stopped, but we don't need to ask the witness about that. I mean, their position is what it is, and I'll allow you to introduce that record for my review.
Okay, then I'll introduce that record along with Judge Mahan's order.
Those are all public records, which the court can take judicial notice of. Just make sure that copies are provided to the court clerk.
Yes, but I would also point out that both sides have argued that res judicata applies to that particular order. We're not in opposition here on that. That res judicata applies there. Okay, I'll move on. Okay, you just go through my outline. I've already covered a number of those, so I'm just going to keep going.
Yeah, take your time.
Mr. Olsen, did you testify at trial about Tara Thackeray being an excuse for not filing or for the delayed filing of the second complaint?
Your Honor, I think we've been through this already.
We haven't.
Yeah, Mr. Stubbs, we covered this pretty thoroughly. Are you going to bring up some nuance that wasn't covered before?
Yes, exactly. I'm asking if he testified at trial that Tara Thackeray was an excuse for the delayed filing of the second complaint.
Yeah, that's the part we've already covered. So what's different about your question? Pardon?
My point is that some false statements were made in their briefs, which I want to bring up later. And so I need Mr. Olsen to testify of whether he testified at trial that Tara Thackeray was an excuse. They've made false and fraudulent filings.
So hold on, didn't we already compare the trial testimony with his affidavit testimony?
We did, but we did not ask the question of whether he testified.
What page? Hold on. What page did you want to refer to in the trial testimony?
That's my point, Your Honor. It's not there. I can't refer to the page that doesn't exist. And
all right, go ahead. Go ahead and ask the question, and I'll see if it's any different.
Okay.
I mean,
Mr. Olsen,
go ahead and ask the question. Let me hear it.
Mr. Olsen, did you testify at trial, that Tara Thackeray was an excuse for delaying the filing of the complaint?
I don't remember ever mentioning Tara by name in any of it.
Okay, so if Mr. Morris filed a brief claiming that you said that would be untrue, correct?
No. I think you need to ask Mr. Morris about that, not me.
Well, Mr. Morris's statement was about your testimony, so I'm asking you.
Mr. Stubbs, please, let's limit this to what was the state of mind of Mr. Olsen before the second complaint. Whatever happened after, what matters is you're saying there was vindictive prosecution, which means that we got to look at the state of mind of Mr. Olsen, but it's the state of mind before the second amended complaint, and his state of mind would not be affected by positions taken by Mr. Morris after that date. So anything that Mr. Morris said after the second amended complaint wouldn't have been known by Mr. Olsen before the second amended complaint because he can't read the future. And so it's not relevant to what his state of mind is. So that's why I need your questions to focus on his state of mind before the second complaint.
But Your Honor, the point is that filings were made in this case, and there were statements in those filings that are absolutely false. And they were
Right,
made
but
by
listen, no, hold on. But go ahead, and if it's a public record, I'll let you introduce it, and I'll have to decide if there's judicial estoppel as to that record. But it's not something that you should be asking Mr. Olsen about, okay?
Mr. Olsen is the one that can refute it, because it's not in the transcript. It's not there. And anywhere. So Mr. Olsen would then either have to admit that he didn't mention Tara Thackeray, which he did. He admitted that he did not mention Tara Thackeray in his trial testimony. Or back up Steve Morris's, false statement. He'll have to do one of the two. And I just wanted to pin that down to show that Mr. Morris has not had candor with this court.
Well, I'm not going to allow that because I think it's completely irrelevant to the issue I have to decide. Mr. Morris is not, his conduct here is only relevant insofar as it might have affected the mental impressions of Mr. Olsen prior to the second complaint. So I'm not seeing the relevance, so why don't you move on, okay?
All right.
It's not apparent to me why it's relevant at all, so move on, okay?
Okay.
But I'm not precluding you from arguing judicial estoppel later. If you're saying that the city took some position for some judicial advantage, which is inconsistent than something that Mr. Olsen said, either today or in his affidavit, you can certainly bring that to the attention of the court, but not during the evidentiary hearing portion, okay?
Mr. Olsen, the original traffic charge, the original one from June 2016, was that a citation?
I believe Sergeant Driscoll wrote a citation. I believe that the remainder of the initial charges against Mr. Hunt were done by criminal complaint.
Okay. And if you look at the city's Exhibit 1, could you do that, please?
Okay.
Can you let me know when you have it?
I have it now, Your Honor.
Okay. So, is this in fact Officer Driscoll's original citation?
It looks like a copy of her citation, yes.
Okay. Did you, in fact, dismiss this citation as well in June 2016?
I don't recall if this citation was dismissed or not.
Okay. But you didn't continue prosecuting it, though, correct?
I didn't what?
You didn't prosecute this citation, correct?
No, I don't believe that we did.
Okay. So it would have had to have been dismissed for you to bring the charge later, correct?
Not necessarily.
Okay. Comparing that to Mr. Hunt's Exhibit 7, the first count.
Okay.
When you charge the second
Hold on. Mr. Stubbs, allow him an opportunity to get there, please.
Okay, I've got it
Well,
now.
he said okay, Mr. Morris. So I'm sorry.
He's
but he
saying
said
okay to where you're going, not to that he's there.
Okay.
Okay, so you're there.
Yes.
Okay. So you included that traffic citation in your June 5th, 2017 complaint, correct?
Looks like that's count one,
Okay.
yes.
So you had, in fact, dismissed this traffic citation prior to this, correct?
I don't recall that was dismissed or not.
Isn't it true that you dismissed it at the exact same time you dismissed the other criminal complaint?
This case that I'm looking at was the one that was filed June 5th of 2017.
Yes, that's the complaint from 2017.
Yes.
And if you look at the June 8th, 2016 citation, that citation was dismissed by you June 22nd, 2016, correct?
With the understanding that we could refile.
Okay. Did
So
you
we
need
did.
any additional evidence for this citation?
I don't believe so.
Okay. So you weren't waiting for anything with this citation, correct?
Not for this citation, no. Not for that particular count in this criminal.
And it was separate and apart. They were two separate cases with the 2016 complaint and this citation, correct?
Count one was under case number 17 CR 68, I believe. I think count two was also that part of that as well.
Okay. That's not the one that I was looking at. So the 2016 complaint that you dismissed on June 22nd of 2016, okay? That was a completely separate case from this citation. This citation that's Exhibit 1 of the defense, correct?
No, I can't say that.
Okay. Let's here it is. Let's look at the city's Exhibit 2. And we'll refer back to that, which you testified earlier is the criminal complaint that you filed on June 13, 2016.
Excuse me, you're referring to the city's exhibit number 2?
Yes.
That's the citation that we previously looked at.
That's criminal
I'm
complaint.
looking at exhibit number 2.
Okay, here we are.
We were on the wrong page.
We're where we need to be.
Okay. So if you look and compare Exhibit 1 with Exhibit 2, those are two completely different cases, correct?
I see 16 CR 108 and 16 BC 0735.
So those were completely different cases, correct?
I dismissed without prejudice.
Okay,
And
that's not what I'm asking. I'm asking if they're two completely separate cases. The citation and 16 CR 108.
Are they two completely separate cases?
Yes.
That would be the right-of-way in a crosswalk and resisting a public officer?
That's 16 CR 108, but comparing Exhibit 2 to Exhibit 1, those are two completely different criminal cases, correct?
They could be. I don't.
Well, how could they not be separate cases? One is a crime that was submitted as a citation, and the other is the criminal case that you filed later.
Right. That we
dealing with
dismissed.
separate incidences.
Okay,
correct?
yes. Yeah,
Okay. So my question is, why did you dismiss the citation?
it was not unusual for us to include the citation on the criminal complaint.
Okay, but you didn't in this case, though, correct? In this case, they were two separate cases, correct?
In this case, I'm not sure what you mean by that. In this case, they were two separate cases.
In this case, what is Exhibit 1 and what is Exhibit 2 are two separate criminal complaints. They're two separate criminal cases against Ms. Correct?
Let me go back and look here. Exhibit 1.
We got to take a 15-minute recess for my staff. We'll come back at 3, and we're going to have to hurry this along, Mr. Stubbs. I've been giving you a lot of time, but we got to. I'm worried we're going to run out of time today, and I'm not sure when we can continue. But anyway, see what you can do with your notes. But I have to give my my staff a break. Court's in recess till 3 o'clock. Okay.
Thank you, Your Honor.